Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers identification laws, traffic violations, and officer commands, and is brought to us by Matthew Soanes' channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into the interaction, I want to give a big thanks to the sponsor of this episode, Surfshark. Surfshark is a premier VPN service that offers its users privacy, anonymity, and security while online. But a Surfshark subscription also comes with a host of other features and options designed to make your browsing experience more entertaining. One of the many perks that Surfshark offers is the ability to bypass region restrictions on popular platforms like YouTube and Netflix and view content that's not normally available in your country. Thanks to Surfshark, I can still catch my favorite Batman movies even though they were removed from the US Netflix catalog. A Surfshark subscription is totally unlimited, which means that you can use it on as many devices as you like, and even on all of them at once. No other VPN service offers that much accessibility. Right now, Surfshark is offering the ATA community an 83% discount with an additional 3 months completely free. With 24-hour customer service and a 30-day money-back guarantee, you have absolutely nothing to lose. So, click the link in the description to claim your exclusive offer now. Thanks again to Surfshark for sponsoring this episode. On July 20th, 2019, 57-year-old Robert Henserling was driving on a roadway in Lamar County, Mississippi when he was stopped by Trooper Caleb Miller of the Mississippi Highway Patrol for an unknown traffic violation.
Yes, sir.
Driver's license, proof of insurance.
What'd I do?
I'll get your driver's license and I'll explain it to you.
I'm working on it. No, what'd I do first? Why you pull me over?
Let me get your driver's license and
No,
I'll
what did you pull me over for? Tell me that first.
Sir, let me explain something to you.
And what's your, I know the law. No, you have to tell me why you pull me over.
I don't have to tell you.
Bull.
Listen to me.
I have driver's
I have
license.
to identify you first.
No, you don't. You have my tag number right there. Are you J Troop or K Troop?
Use driver's
Who
license
are you?
and proof of insurance.
No, what did you pull me over for first?
Sir, you can be difficult. Or
I
you
do a
can
what?
be-
I'm not trying to be difficult.
You
I'm
are
just
being
telling you.
difficult.
I'm not. And you're also, anyway, I'm just asking, why did you pull me over first? I did one wide open throttle. I'm a diagnostic mechanic. And you also pulled my son over the same thing too, Caleb Miller. You saw me at Rose's one time with an open carry weapon. I'm just asking, and I know Jamie Atkins and all the bunch, whatever, but why did you pull me over? Why? Need to know that first.
Let me
No,
get your driver's
you have
license.
my tag number. You can run it and get
Just
my
because
name.
it's tag number doesn't mean it comes back to the driver's vehicle.
It does show the insurance though on the thumb.
Listen, that's correct.
No,
But I
but
can still-
tell me why. You have to tell me why you pull me over. You haven't identified yourself yet. I see a uniform. I see a vehicle. Okay. Why did you pull me over?
Listen to me.
I did a wide open throttle.
Listen.
Real quick. I'm a diagnostic mechanic. I'm working on a truck, and I'm heading toward a guy's house to help me with it in Columbia.
Let me explain something.
I am listening. No, you don't have to explain. That's a cop's plane. No.
I
No.
need to identify who I'm speaking with. I'll explain to you why.
I
I'm
am
trying to
Robert
drive
B. Henserling. My birthday is 6/22/62. I own this truck, and I have registration and everything. You don't have to know that. Tell me why you pull me over.
Mr. Henserling insists that Trooper Miller is obligated to inform him of why he has been stopped before he surrenders his driver's license, but he does tell the trooper his name and date of birth and admits to owning the vehicle. In general, police officers must have reasonable suspicion of a traffic violation or criminal activity to pull over a vehicle, but they are not legally obligated to inform citizens of the reason for traffic stops, although it may be policy or standard practice for many departments. In fact, in the 1996 case of Wren versus United States, the Supreme Court held that the actual reason an officer pulled over an individual is irrelevant to the constitutionality of a traffic stop. The court explained that, quote, "Not only have we never held that an officer's motive invalidates objectively justifiable behavior under the Fourth Amendment, but we have repeatedly held and asserted the contrary. We think these cases foreclose any argument that the constitutional reasonableness of traffic stops depends on the actual motivations of the individual officers involved." In other words, as long as there existed some objective reason that would warrant conducting a traffic stop, the stop is considered to be constitutional, regardless of the real reason the officer pulled an individual over. Conversely, while officers do not have a duty to explain the reason for a traffic stop, drivers are legally required to display their license upon request to a police officer. Section 63-1-41 of the Mississippi Code states that, quote, "Every licensee shall have the required license in his immediate possession possession at all times when operating a motor vehicle, and shall display the same upon demand of a peace officer. There is no contingency in the statute that requires officers to prove to the driver that they had a reasonable suspicion to stop them for this obligation to apply, and therefore Mr. Henserling was legally required to display his license to Trooper Miller. If Mr. Henserling believed that he was pulled over unlawfully, the best course of action would have been to comply with the demand to display his driver's license and challenge the validity of the traffic stop in court if he was charged with an offense. He could also express his concerns about a baseless traffic stop by filing a complaint with the Mississippi Highway Patrol.
I know who you are, and I know you know Jamie Atkins, R37, okay? I'm not naming names, but you have to tell me, you know, who you are, identify yourself. You do. I own this truck. You can run my tag number. Brand new tag, brand new license. Tell me why. There's my proof of insurance. It has my name on it right there. I don't have to hand this to you. All I have to do is just show you. I'm not trying to be difficult. I'm asserting my right. No, I'm a nice guy. I'm a really nice guy.
Am I not being?
You are, but I don't have to. I don't have to do that. Now, tell me why you pulled me over. Tell me.
You step out of the vehicle.
No. In fact, I'm gonna lock my doors or I went up a little bit too. I just need to ask. I'm going to a friend's house in Columbia right now. I did one wide open throttle on my truck. I just took it 1,200 mile round trip. Jamie knows that. I sent him all the information, whatever. You know, I did one wide open throttle. I was not reckless driving. I did one wide open throttle on the truck. I let off.
Mr. Henserling admits that he, quote, did one wide open throttle, which means that he fully depressed the accelerator pedal of his truck for a brief period of time. He also informs Trooper Miller that he is a diagnostic mechanic and implies that he was conducting a diagnostic test when he accelerated. First, it's important to note that while mechanics often road test vehicles as part of the repair process, they're not granted any special privileges to violate traffic laws while conducting these tests. However, it's typically not illegal in and of itself to rapidly accelerate in a vehicle while remaining under the speed limit. Still, there may be some situations where rapid acceleration could be unsafe, which could make it illegal. Section 63-3-1213 of the Mississippi Code states that, quote, any person who drives any vehicle in a careless or imprudent manner without due regard for the width, grade, curves, corner, traffic, and use of the streets and highways and all other attendant circumstances is guilty of careless driving. And Section 63-3-1201 states that, quote, any person who drives any vehicle in such a manner as to indicate either a willful or a wanton disregard for the safety of persons or property is guilty of reckless driving. Reckless driving shall be considered a greater offense than careless driving. While simply accelerating a vehicle would not ordinarily be considered a violation of either of these statutes, an individual could be potentially convicted of careless or reckless driving for rapidly accelerating around a dangerous curve, or in such a way that it posed a risk to other vehicles on the road. In this situation, because Trooper Miller refused to explain the reason for the stop, it's impossible to say whether he was within his authority to pull Mr. Henserling over. If Trooper Miller did conduct the stop solely because of Mr. Henserling's acceleration, it is likely that a court would conclude that he did not have reasonable suspicion to pull Mr. Henserling over, unless the wide open throttle was conducted in an unsafe manner.
I saw you way back there, sitting back there. I have you on video right there.
That's fine. You're being on video on my video.
That's fine. That's really cool. I appreciate that. I really do.
You want to step out of your truck?
No, I'm not stepping out.
You want to step out of your truck, man?
No.
There's no reason to be difficult, man.
There's no reason to step
there's two
out
ways
either.
this can go.
There's no reason
Look, I'm
either.
going to give you a couple options. Okay?
No.
You can,
No.
either, you can either get out of the vehicle or give me
No.
a license.
I can give you my license, but I'm not stepping out of the vehicle.
Give me a license.
No. It's very dangerous for me to be out, stepping out, you know, in this situation. You don't know me. I don't know you. No.
Listen to me. Get out of the truck.
No.
Get out of
There's
the truck.
my license
Get
right
out of the
there.
truck. You're being disorderly.
No.
You're giving a lawful command. Get out
There's
of the
my
vehicle.
license. It's not a
Get out of the
lawful
vehicle.
command. No.
Get out of the vehicle.
No.
Get out
There's
of
no
the vehicle.
reason for this.
Quit reaching under the seat. You leave that license
My
right
gun's
there.
over there. There's no reason for this. Here's my brand new license. Jamie just got me this license. Do not do that. No.
Get out of the car. Get out of the truck. Get out of the truck right now.
There's no reason. You
Get
did
out of
this
the
to my
truck.
son.
Get out of the truck.
No. That,
You're
There's
under
no
arrest for
reason.
You're under arrest for disorderly conduct.
I didn't do anything.
Failure to obey a lawful command. Get out.
Trooper Miller orders Mr. Henserling to exit the vehicle, but he refuses to do so. Trooper Miller then informs Mr. Henserling that he's under arrest for disorderly conduct as he begins to pull him from the vehicle. As we have discussed many times on ATA, the Supreme Court held in the 1977 case of Pennsylvania versus Mims that once a vehicle has been lawfully detained for a traffic violation, officers can order the driver to get out of the vehicle without violating the Fourth Amendment. Here, Mr. Henserling's refusal to comply with this command likely constituted a violation of Mississippi's disorderly conduct law. Section 97-35-7 of the Mississippi Code states that, quote, "Whoever, with intent to provoke a breach of the peace, or under such circumstances as may lead to a breach of the peace, or which may cause or occasion a breach of the peace, fails or refuses to promptly comply with or obey a request, command, or order of a law enforcement officer to arise, if lying or sitting down, and move to a point designated by said officer outside the immediate area of, or which is affected by the occurrences at, the place of issuing such order, command, or request." In the 2014 case of Rogowski versus State, the Court of Appeals of Mississippi affirmed a disorderly conduct conviction under very similar circumstances to Mr. Henserling's. In this case, a driver refused to show his driver's license to an officer upon demand. The officer then opened the vehicle door and unbuckled the driver's seatbelt. The driver responded by locking his arms and legs and refusing to get out of the vehicle. He was then forcibly removed from the vehicle, and after a few moments of struggle, he was handcuffed and arrested. Given the similarities between these two confrontations, it's likely that a court would conclude that Mr. Henserling could be convicted of disorderly conduct in this situation.
There's my
Get out of the
license
truck.
right there. No. 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 Stop it.
Get out of the truck.
Stop it.
Get out of the truck. Get out of the
You
truck.
can call Jamie
Now.
Atkins right now.
Get out of the truck.
I have my license on. I have my seatbelt on. I didn't do anything wrong.
Get out of the truck.
No. You call R37 right now.
Get out of the vehicle.
No.
After wrestling with Mr. Henserling for several minutes, Trooper Miller manages to extract him from the vehicle and place him into handcuffs, with the aid of a passing citizen. Mr. Henserling was arrested and taken to the Lamar County Jail. He was charged with driving under the influence, speeding, following too closely, and resisting arrest, to which he pled guilty on all charges. Ultimately, Mr. Henserling was ordered to spend 13 days in jail and pay a total of $1,785 in fines and associated fees. It is unclear whether Mr. Henserling filed any official complaint or lawsuit. Overall, Trooper Miller gets a B+, because although he could have made a stronger effort to de-escalate before employing the use of force, he maintained a relatively calm and professional demeanor, offered Mr. Henserling several opportunities to obey his commands, and remained within the bounds of his authority throughout the interaction. While there is certainly an argument to be made that Trooper Miller may have been able to reason with Mr. Henserling if he had continued talking with him, there's no legal doctrine that assigns a rigid guideline for when officers should stop de-escalating an encounter and start employing the use of force to control the situation. Before the trooper managed to open the door to the truck, Mr. Henserling informed him that a firearm was inside the vehicle, essentially justifying the trooper's initial order to exit the vehicle. The Mims ruling was designed to mitigate the potential dangers associated with interacting with citizens while they are inside of their vehicle, with the potential for hidden weapons typically being cited as the primary motivation for asking a citizen to step out. By admitting to the presence of a weapon inside the vehicle, Mr. Henserling provided Trooper Miller with a legitimate justification for ordering him out of the vehicle and using force to compel his compliance. The courts have routinely offered members of law enforcement a broad spectrum of discretionary authority to do whatever is reasonably necessary to ensure their safety, and this interaction highlights how that authority can manifest itself both in practicality and within the courtroom. Mr. Henserling gets an F for displaying a fundamental misunderstanding of Mississippi's identification laws and constitutional rights in general, failing to invoke his right to silence, and for disobeying several lawful orders and physically resisting a lawful arrest. Mr. Henserling made several critical errors during this encounter that largely stem from his misconceptions regarding Mississippi law and the Constitution, and his failure to invoke his right to silence likely would have had a dramatic impact on his case if it had gone to trial. One aspect of this encounter that should not not be overlooked for members of law enforcement is the fact that Trooper Miller decided to use force without waiting for backup to arrive. The trooper also did so with the knowledge that a firearm was inside the vehicle and within reach of Mr. Henserling. Most law enforcement professionals would likely advise against attempting to apprehend a potentially armed suspect without other officers present to assist. And Trooper Miller's premature decision to engage with Mr. Henserling prompted a nearby citizen to put themselves in danger in an effort to help the trooper. If this interaction had evolved into a shootout, then the trooper could have put himself at risk for civil litigation if anyone was injured as a result of his failure to follow departmental policy. Before attempting to physically remove Mr. Henserling from the vehicle, Trooper Miller may have benefited from returning to his patrol car and contacting a supervisor, or ensuring that backup was on the way at the very least. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.